For decades, Americans have trusted the Supreme Court as the great equalizer of power in our democracy, a scale meant to hold steady no matter which way the political winds blow. But today, that scale is tilting. The mechanisms designed to keep the court balanced, accountable, and trustworthy are showing signs of serious wear. This is a blueprint for understanding what's broken and how we might rebuild it. The numbers tell a stark story. Public confidence in the Supreme Court has fallen to just 22%. This isn't a passing dip tied to one controversial ruling or election cycle. It's a structural problem, years in the making, built from a combination of opaque decision-making, perceived political influence, and a growing sense that the court answers to no one. One of the clearest cracks in the foundation is the absence of a binding, enforceable code of ethics. Unlike every other federal judge, Supreme Court justices have operated for most of their history without a mandatory ethics framework. Undisclosed gifts, luxury trips, and financial entanglements have surfaced repeatedly with little consequence. An institution built on public trust cannot survive without real accountability. The rise of the so-called shadow docket is another concern. Increasingly, the court is issuing consequential emergency rulings with none of that transparency. No argument, often no explanation, sometimes no signed opinion at all. Decisions with sweeping national impact are being made in the shadows. Another crack emerged when the court granted presidents broad, and in some readings, absolute immunity for official acts. The founders designed a system of checks meant to hold the executive accountable. Recent rulings have opened what some call an immunity vacuum, a gap where the accountability the Constitution promised no longer reliably applies. Meanwhile, the confirmation process itself has become a battlefield. What was once a largely bipartisan, deliberative process has devolved into all-out political warfare, with each nomination fought as an existential contest for control of the court's ideological direction for a generation. The gears of confirmation are grinding against each other instead of turning together. At the heart of many of these problems is a single design flaw: untethered lifetime tenure. When the framers wrote the Constitution, the average justice served around 15 years. Today, thanks to longer lifespans and strategically younger appointments, that average has stretched to 28 years or more, turning a single confirmation into a decades-long lock on the court's balance. Compare that to the other two branches of government. The presidency is capped at 2 four-year terms. Senators and representatives face regular re-election. Only the judiciary lacks any temporal check at all. A branch designed to be independent has become, in practice, entirely insulated from time itself. But here's an important truth. Congress already holds real constitutional power over the court. Article 3 gives lawmakers authority over the court's structure and jurisdiction. The tools to recalibrate the system already exist in the Constitution. What's been missing is the political will to use them. One leading proposal: replace lifetime tenure with staggered 18-year terms. Every president would get one appointment every 2 years, regardless of vacancies or the luck of timing. This would make the court's composition more predictable, more evenly distributed across administrations, and less dependent on the randomness of mortality. Beyond term limits, reformers have proposed a broader ecosystem of interventions: stronger ethics enforcement, greater transparency in the shadow docket, and clearer checks on emergency rulings. Like architectural pillars, these reforms are designed to work together, reinforcing accountability, transparency, and balance throughout the system. One especially promising mechanism: a fast-track legislative override. When the court strikes down a democratically enacted law on shaky constitutional grounds, Congress could have an expedited path to review and respond, restoring a dialogue between the branches instead of leaving the court's word as the final, unchallenged verdict. Put side by side, the contrast is clear. Under the status quo, lifetime tenure, minimal ethics enforcement, an opaque shadow docket, and a broken confirmation process. Under a reformed architecture, defined terms, binding ethics rules, docket transparency, and a confirmation process insulated from pure political brinkmanship. Rebuilding the bench isn't about weakening the judiciary. It's about restoring the balance the framers intended. A scale only works when both sides can move, adjust, and settle back to equilibrium. With thoughtful, structural reform, we can recalibrate the court not as a political weapon, but as the steady, trusted balance our democracy was built to rely on.